You're watching The Attorneys, a paid advertisement brought to you by the law firm of Hollis, Wright.
Car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts with The Attorneys of Hollis Wright.
Welcome to The Attorneys. I'm Art Franklin. We're so glad to have you joining us. We're talking about settling disputes without going to court. Now, there's a lot to unwrap with that. We're going to get into it in just a second. But as we begin the show, we want you to know that attorneys at Hollis Wright, they are standing by right now. They'll be on the phones throughout the show. And you can reach someone right now by calling 844-LAW-TALK. That's 1-844-LAW-TALK for a free confidential call with the attorneys at Hollis Wright. And we're talking about solving disputes without going to court. Carter Clay is here, and one of the top mediators, right?
Absolutely, Art. I'm going to show my age a little bit, but when I was getting out of law school in 1999, what we're talking about here today was really just a concept. And I actually took a course in law school called Alternative Dispute Resolution, now referred to as ADR. And the idea is that a lot of the disputes, the lawsuits and things that are pending in court could be better served by going to a process and trying to get them resolved without having to go to court.
So you're on the cutting edge then.
Well, yeah, so to speak, not quite. But so that's where that concept originated, and it's really just grown from there. And we are very fortunate in the Birmingham area and really north central Alabama to have Jon Lewis serving in the capacity as a mediator, and we'll talk about what that is in just a minute. But Jon, welcome to the show.
Thank you very much. Just glad to be here. I appreciate you having me.
Yeah, well, tell us a little bit about your background, the current status of your practice, and kind of how you got involved in mediating cases and this concept of ADR.
Yeah, so I've been practicing law here for 35 years. I worked for a big firm, and then I worked with my dad. Most of my work has been personal injury plaintiffs type work like Hollis and Wright does. And just like you, there was no ADR when I started. So
they probably didn't even have that in law school.
Not at all, not at all. In fact, we barely had computers in law school.
Fair enough.
But so, you know, in the late 90s, early 2000s, when it started becoming a little more prevalent, and it was that time that we started mediating as attorneys. Yeah. And so through the years, I've really gravitated toward that and really enjoy it.
Yeah, well, that's great. So mediation, there are all kinds of different forms, I guess, of alternative dispute resolution. People just getting together in a law office and settling their case is a form of ADR. But what we're going to talk about here today principally is mediation. Talk in general about what that is and kind of define it for us.
Yeah, mediation is where you have a neutral third party. So if I'm the mediator, I'm the neutral third party. And usually, and it doesn't have to be this way, but usually there's, let's just say, a plaintiff with their attorney, a defendant with their attorney, and the mediator tries to help them communicate and collaborate and resolve their case without having to spend time in court.
And when typically does the mediation take place? Is it before a lawsuit's filed? Is it after a lawsuit? Is it at any point in between? And do you have an idea or a judgment as to when mediation can work best?
You know, most mediations that we deal with in the legal community are after a lawsuit's been filed, but that does not have to be the case. I've recently mediated a couple cases that were pre-litigation, as we call them. And sometimes you mediate cases even after a jury's given a verdict and it's on appeal, the appellate courts are ordering mediation. So it can happen at any time throughout the process.
Yeah, and I think before we got started here today, you were telling me that you're moving and transitioning to where you're going to be basically doing mediation, serving as a mediator on a full-time exclusive basis.
I am. I think I have about 10 litigation cases left. I'm not accepting new cases on that front. I'm just doing mediation. I'm looking forward to continuing to help people such as yourself resolve your case.
Yeah, well, you've done some mediations for us recently, which we really appreciate. So talk in terms of what the actual mediation process looks like.
So usually attorneys call and they want to schedule a mediation, and at that point in time we pick a date, and they usually come to my office. It can be virtual, it can be at one of the other attorneys' offices. And typically both parties, and it can be more than 2 parties. I had a recent construction case, it was 8 parties. But people provide you with what's called a position statement, and the mediator reviews all the records and the position statements. And then when we all get together, we talk about the issues of the case, we talk about the risk of the case, the different aspects of the case, and hopefully people can come together and collaborate to reach that resolution.
And I know sometimes some people participate by Zoom or remote, but otherwise the people that are there in person, you're basically putting them in groups or pods in various conference rooms, and do you go back and forth between the rooms, getting their versions of events and try and figure out what's going on?
It's interesting, you know, when we started years ago, like we were talking about, we would have a joint session with everybody in the joint session, but that's kind of gone away. So yeah, we call those caucuses, and we're each in separate rooms, and if it's virtual, they're breakout rooms on Zoom, and we put people into different rooms. And I go into each room and talk about the case with the client and the attorney, move back and forth from different rooms, and it's a shuttling process. I get a lot of steps in sometimes.
Yeah, absolutely. Now, so let's take it just in the civil context. We handle personal injury cases at our firm where we're filing a lawsuit and we're seeking a monetary recovery compensation for our plaintiff. So we're seeking money. In the personal injury realm, are you literally doing like offer and counter offer back and forth kind of all day long, trying to get them to arrive at a middle point?
That is what is happening, but there's a lot more to it than that. You know, people think these cases are just about money, and as you know, there's a lot more to it. There's time, there's risk, there's emotion, which to me is one of the biggest issues in these cases. So we're talking about all of those things in addition to the money. I don't like to be considered somebody who's just carrying a dollar figure back and forth, because I think we really have to consider other factors.
Well, you've obviously got to consider the facts and the law as it relates to why one party may want a certain amount of money and why another party may not want to pay it, right?
Right.
Yeah.
You definitely have to figure that. You know, a lot of times, though, one of the problems is parties come in wanting to win their case at mediation. And I tell people, you know, this isn't the place to win or lose your case. You want to win or lose your case, go to court. You want to try to collaborate and resolve your case, this is what we're here about today.
So what are sort of the main reasons why you would recommend or believe that when somebody's in a dispute, they ought to consider mediation as opposed to going to court?
I think over the years I've seen it, litigation continues to take more and more time to get to an ultimate resolution. So that's one factor. The other factor is, being an attorney who's handled a lot of plaintiffs' cases, I've seen the relief that comes when my client's case faces when their case is either settled or tried. They don't realize the stress that they're under during the litigation. The sooner you can get that resolved, the better.
And talk about the control aspect. I think that's a big factor that mediators always emphasize, which is in a mediation setting, you have control over, somewhat control. I mean, obviously the other side's got influence and control too, but if you go to court and you're in front of a judge or a jury, you have no control. You're leaving it up to 12 strangers or a judge to decide.
You're absolutely right. What I have found is, at least with my clients and during mediations, people really don't know what happens in court, and they really don't know the process. Yeah. So when they're going to court, especially if it's a jury, you're talking about 12 people you've never met who are going to meet you for 2 or 3 days, depending on the case, and they've got to unanimously come to a conclusion as to whether you win and how much you get. Yeah. Whereas when, like you said, when you're in mediation, you get to talk about it and you get to make that ultimate decision and not leave it up to that judge or jury.
Yeah. Carter, before we leave the process, is another aspect of that. A lot of people think of a mediator as a judge. What's the difference between the judge and a mediator?
Well, a judge decides your case, or at least rules on the legal issues in your case if a jury is deciding the case. A mediator can't decide anything. All we can do is help facilitate and help you make the right decision for your case.
Yeah. When we come back, now we're stepping out to a break, but when we come back, we're going to talk about other types of cases beyond personal injury that may be ripe for mediation, because a lot of people out there have disputes that don't have anything to do with a personal injury.
That's good. Settling those disputes without going to court. That's the subject of this, attorneys. And we're so glad that you're joining us. I want to remind you, though, you can also join us on all of the social media platforms, whether it's YouTube, Facebook, Instagram, X, even TikTok. You can find us there as well. Go ahead and find us. And you see something good, see something you really like, share it with someone. keep it going. We're going to take a break. We'll be back right after this.
Here's some good information from our firm to you. Hollis Wright recently launched the Law Talk podcast. With podcasts becoming so popular, this will be a simple way to provide our loyal viewers with more opportunities to access information about important legal topics and to learn more about our firm and how we can help you if the need ever arises. There are many ways to access the Law Talk podcast. You can simply scan the QR code on your screen. Also, episodes are always available on the Hollis Wright YouTube channel, as well as on Spotify, Apple Podcasts, or wherever you consume your podcasts. Just search up Hollis Wright in the Law Talk podcast. Don't wait, take advantage and listen today. Thanks for watching The Attorneys, and we know you'll enjoy the Law Talk podcast.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best. Help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas, such as bankruptcy, criminal law, civil law, such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
Addiction kills hope.
But at Bradford, it all changes here.
Experience the difference
that proven treatment can make.
Find recovery, find community.
at Bradford.
You're watching The Attorneys, a paid advertisement brought to you by the law firm of Hollis Wright.
Welcome back. We are talking alternative dispute resolution and mediation with Jon Lewis, and we're going to continue that show. But also want to remind you that you can still reach someone at Hollis Wright. It's 1-844-LAW-TALK. It's really that simple. Call 1-844-LAW-TALK, and you can reach someone for a free and confidential call with Hollis Wright. As we continue this conversation, there's still many things to unpack about both mediation and alternative dispute resolution.
Absolutely. So at Hollis Wright, we operate exclusively in the practice area of personal injury, and that's when we would go and see somebody like Jon to try and mediate our case with the opposing side to try and get a monetary settlement, get it resolved. But obviously there are a whole host of other legal disputes and lawsuits that exist out there that don't have anything to do with personal injury. So Jon, I guess my question to you is, are there other cases outside personal injury that, number one, you believe are ripe for mediation, and what are those types of disputes?
Absolutely. Anything can be mediated, really, but employment disputes, there's a lot of employment discrimination, workers' compensation, those can all be mediated. Construction claims, I've mediated several construction claims. Those are really good for mediation because there's usually a lot of different parties. Domestic cases can be mediated. Family disputes, divorce proceedings, it's really good for those so that they can iron out all the issues that can come from a domestic dispute. And even in some jurisdictions, believe it or not, they've mediated some criminal cases. We haven't really done that here, but that's been done.
Yeah, I've never needed the services, thankfully, of a mediator in the context of a divorce, but I had a mediator one time tell me, you had talked about the emotions running high. They really run high in divorce mediations. And I had a mediator tell me one time, he's like, look, sometimes these people will spend $10,000 fighting over a $500 utensil set in their house. He was like, that. Do you run into that from time?
It's crazy. I haven't done a domestic case, but I have taken the courses, especially with domestic violence.
Right.
The other thing you really got to concern yourself with in those types of cases is do you want to do them virtually or do you want them in the same office? Because that can be very harrowing.
Yeah, that's one. Again, personal injury space, generally I prefer to have everybody there in person, and I certainly want the liability insurance adjuster there as well. I don't want them remote, but now that you mentioned that, I could see how the opposite may be true when you're doing a divorce mediation.
Exactly.
You may not want them in the same building, let alone the same room.
And even, you should consider that with the personal injury case if there's really high emotion, high tension.
Yeah.
It could be beneficial not to have them too close together.
Talk a little bit about this, because I do think this is, whether it's a personal injury case, a divorce case, I think there's a big misconception about how long a mediation takes and really how long a trial takes. I mean, I'll have a product liability case and I'll tell the clients, look, if we have to try this case, it could go 2 weeks. And they look at me like, 2 weeks? They were like, we can't get this done in a day or two? And I was like, no. I was like, you'll understand if we actually have to try this case. But mediations, talk about how long they last.
Most mediations, especially in the personal injury realm, are either a half day, which is about 4 hours, or a full day, which is about 8 hours. I've had mediations that go to 8 o'clock at night. And then there are a lot of mediations, especially depending on how many parties there are. I mean, you could have a class action mediation that could take months, but most of them do it in a half day to a day. Even if they don't resolve during that time, we usually follow up and continue to try to help the parties resolve the case, so it could linger on for a little bit.
Well, and that is an essential character trait that I require in all of my cases that I mediate. I want the mediator to be willing to work beyond the day of the mediation, because as you know, a lot of times the day of the mediation can be a foundational type day for everybody to learn the strengths and weaknesses of the case, for you to be able to get a good idea as to what it's going to take to settle it. And then sometimes the real negotiating, the real compromise, and the real work comes afterwards.
And sometimes people just have to sit on it and think about it.
Yeah.
I think sometimes during the mediation, things are going fast, especially for a client who really is not familiar with the process, and they sit on it for a few days and they have some thoughts about it, and it can really change their idea. And also, you're narrowing the issues during the mediations. So if nothing else, you're narrowing those for either a future trial or continued negotiation.
Yeah. What skills do you think are required or important that a mediator possess to be an effective mediator?
I think patience is one of the key issues. We have to be patient. A lot of clients, especially on the plaintiff side, want to tell their story. And you want them to get that out. You don't want to undercut them or cut them off. So that's a really good characteristic. Communication, knowing how to frame questions, that's an important skill. But probably the most important skill, and what the statistics show, is that building rapport with all the parties is what really builds trust and works towards a settlement.
Yeah, now it's important for the viewers and really even my clients to understand that for you to mediate a case, you have to be neutral. You have to be independent, and you cannot have any financial stake, certainly, in the outcome of the case. Is that right?
Correct.
Yeah.
That would be a problem.
That would be a problem. But sometimes people will ask us that question, well, who is he? Is he on their side, so to speak? And we have to explain to them that no, he has to be 100% neutral. He has no financial stake in the outcome of this, because honestly, this will not be hard to believe. Lay people out there are oftentimes a little bit skeptical and suspicious of lawyers and motives and things of that nature. So it's kind of a natural response sometimes.
There's two things I do at the beginning of mediation, and one is I introduce myself to the parties because they don't know who I am and they don't know why I'm here. So I like to do that, even on a personal level. And then I also tell them, because I am a human being and I do have facial expressions and tones, that if they don't think I'm being neutral at any time during the process, to let me know, because I can't address it if they don't. The other thing, and getting back to the financial interest, you can't handle mediations on a contingent fee basis, i.e., you can't say, I won't get paid if it doesn't settle.
Right.
So.
Yeah. Are mediations confidential, number one? And number two, can one party use what happens at a mediation against the other party at trial if it does not settle?
As you know, the evidentiary rules do not permit admissibility of settlement discussions. And mediation is pretty much all about settlement discussions. But there are actually mediation rules that the court has promulgated, and there's a statute, and everything is confidential so that everybody can be candid and talk about the issues and not worry about what happens at court. No one can subpoena me to court and ask me to testify about what was discussed in mediation. And if they do, all I can say is it settled or it didn't settle.
Yeah, because we've had that come up before, Art, because something will transpire to mediation, and after the fact, if we don't settle and we're getting ready to go to trial, the client will be like, well, you remember they told us that at the mediation, or they said this at the mediation, and I'm like, well, their lawyer told the mediator that, and the mediator told us that, but the reality of it is neither side can use any of this against either side, and it's just not admissible at all at trial.
But it makes a big difference to have that mediator.
Yep.
That's why we got Jon Lewis here to talk about that. And we want to remind you, we've got one last opportunity in this show for you to reach out to someone at Hollis Wright. Call 1-844-LAW-TALK. It's simply that easy to do so, and you'll reach someone on the other end of the line from Hollis Wright. They will give you an answer to your question, and it's a free confidential call. It's really that simple. We're going to take a break. We're going to wrap things up when we come back. Stay with us. You are watching The Attorneys.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK, and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon.
If this place could talk, it wouldn't. It would sing and celebrate all of our stories of addiction recovery, victory, and community. This is Bradford Health Services. It all changes here.
You're watching The Attorneys, a paid advertisement brought to you by the law firm of Hollis Wright.
Solving disputes without going to court. That has been the topic on this, Attorneys. We're so glad to have you with us as we begin to wrap up. But before we do that, I want to remind you to make sure you join us on all the social media sites, and a lot of great information that you can share there. Also see some of the behind the scenes information with Hollis Wright. It's great stuff, good content there. Good to have you with us again as we start to wrap up, Carter.
Yeah, so up to this point, we've principally talked about mediations, which is a process to kind of get the parties together, understand the issues, and somebody like Jon Lewis serving as a mediator will help bridge any gaps and try and move the parties to a compromised resolution to the case. But in a mediation type setting, a mediator does not have any authority to force the parties to do anything. A mediator does not have the ability to rule in favor of one party or another. Mediator is truly only a facilitator to try and get a compromised agreement. Now, I want to transition to arbitration and talk about what an arbitrator does, because those terms are entirely different, but oftentimes, and I see it in my practice all the time, where I have a client that says, so are we still going to arbitration? And I'm like, no, we're going to mediation, and I have to explain the difference to them. So, John, let's talk about arbitrations. How is an arbitration different than a mediation, and do you do arbitrations?
First, I will say there's another confusing aspect, because a lot of people don't understand mediation and it's not meditation.
Well, that's a fair point, too. Although sometimes you need to meditate at mediation,
correct,
right?
Now, arbitration is where usually it's an attorney or a former judge, and it's kind of a private trial. It's almost like trying a case before a judge, and the arbitrator has full authority to make a decision on the case. It can be voluntary, but you find that most arbitrations are from contractual language where they demand that you go to arbitration, and that's usually enforceable.
Yeah, two times that could jump out at me is nursing home disputes. Oftentimes you see arbitration agreements in nursing home admission documents. So if you've got an issue at a nursing home, may be subject. And then also car dealerships.
Correct.
That's a big one for the last 20, 25 years. People who buy cars, they're they're unsatisfied, they want to file a lawsuit, they're probably going to go to arbitration then.
Correct.
All right. So do you do arbitrations?
I do. For anybody who's interested more in this subject, there's the Alabama Center for Dispute Resolution run by Eileen Harris. It's great information. You can look it up online. They have just a wealth of information.
Okay.
And I'm registered there as an arbitrator and a mediator.
All right. In terms of what the hearing or the process looks like, how is the process of an arbitration different than the process of a mediation, and how long do they typically last?
So the last arbitration I was involved in as an attorney was a nursing home type case, and that case took 3 or 4 days, but it's similar to a court case where you do discovery, which is when you question other people, other parties, and get information from them, and you go have a hearing and you put in evidence before the judge. So it's very similar to a bench trial before a judge. It's a little streamlined though, because they want it to be more efficient, and they don't allow you to do as much, and it's a little more flexible than in court.
Yeah. Now, if I filed a lawsuit in court for somebody and we were having a bench trial, my tax dollars go to pay the judge. I don't have to pay, other than a filing fee, I'm not having to pay the judge to sit there for hours listening to evidence and testimony. Is it the same for an arbitration? Who pays the arbitrator?
It is absolutely not the same.
Okay, I didn't think so.
And a lot of arbitration are done through what's called the AAA or American Arbitration Association. And they require fees to be paid to the arbitrator. And typically if it's a commercial case, everybody splits the cost of the arbitrator. If it's a consumer case, however, the commercial entity usually has to pay the arbitrator, except for a small fee that the consumer has to pay.
Yeah. Why would somebody who doesn't have to go to arbitration might choose, or the parties might agree to go to arbitration as opposed to going to court? And is that something that you see?
Yeah, a lot of times it's between two commercial entities, or it's a subject matter that's very specific, and they want an arbitrator who's knowledgeable in that subject matter. So it makes a little more sense to do it that way. I think, although most of the arbitrations are forced through contractual language.
Yeah, and I would think also you can get to a much quicker resolution of the dispute by going through arbitration, because oftentimes you've got a backlog in the court system, so it takes quite a while to get your case heard in court.
That is true, although if the arbitrator doesn't really take control, it can drag on too. So it really kind of, just as in court, it depends on the judge, it depends on the arbitrator in enforcing the schedule.
Yeah, yeah. Been a great conversation, Art, and one of the other aspects to arbitration is that I suppose the arbitrator could, quote, rule from the bench, if you will, but oftentimes the arbitrator will write out a written order that will explain the findings. But a lot to unpack here, and there's a lot more in these areas, but I would encourage anybody to get in touch with Jon Lewis if they've got a dispute that they want to either arbitrate or mediate.
Absolutely. Jon, thank you. Really do appreciate it. On behalf of Carter Clay and everyone at Hollis, Wright, all the staff here in the studio as well, we thank you so much for joining us for another edition of the show. Go ahead, make an appointment. Join us again next week, same place, same time. We'll do it again. We'll give you another great show for the attorneys. So.
Thanks for watching The Attorneys, sponsored by Hollis Wright.